You raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes.
Please have a seat. You would adjust yourself close to that microphone, about a fist away from the mic, and it moves up and down for you. You would please tell us your name and spell it for the court reporter.
My name is Allison Saylor, ALLISON
Vince?
Thank you, Your Honor. And Ms. Saylor, thank you so much for being here. I really appreciate it. If you could please, you've already introduced yourself to the jury. If you could tell them how you're employed.
I am a probation officer here in Hays County.
And as a probation officer here in Hays County, are you responsible, at least partially, for supervising individuals that are placed on community supervision or commonly called probation?
Yes.
And what is community supervision or probation at a very high level?
So defendants on probation, they are given conditions in which they have to abide by those conditions. Everything from if they change their phone number, they have to let us know, not getting arrested, their order classes, community service. And so we are making sure that they stay out of trouble and complete the court-ordered conditions.
Okay, and there's those standard conditions, those are found in chapter 42. And those, is it fair to say that the court assesses what conditions may be appropriate in any specific defendant's situation?
Yes, we have a standard set of conditions that everybody is ordered.
Okay.
And then the court would add on specific conditions that are pertinent to the defendant and the particular case.
Okay. And those standard conditions could be from the time that somebody is placed on community supervision, from the time that somebody is sentenced to community supervision, would be not committing any violations of the laws of this state or any other state or the United States.
Correct.
That they would maintain suitable employment.
Yes.
That they would support their dependents, I'm sorry.
Yes.
That they would report as directed to a community supervision officer, somebody like you or another officer in your department.
Yes.
That they would undergo an evaluation for the necessity of any alcohol or drug treatment.
Yes.
Tell me more about that.
So we kind of have a step process. In a normal case where like a plea bargain is struck, there would be the pre-sentence investigation report, and we would talk to the client about their substance use history. From there, there's a tool called a SASE 4. At this point, I forget what SASE stands for.
I won't ask you.
Yeah, but it'll tell us whether there's a low probability of a substance use disorder or a high probability. From there, sort of just based on our experience in dealing with people with drug and alcohol issues, we would make a recommendation, whether it be everything from outpatient from at the low end, and then at the high end, safe P, which is within the TDCJ facility. And then if we're still kind of having issues, if we don't really know where the problem lies, we do have licensed chemical dependency counselors on staff, and they can prepare a formal substance abuse evaluation.
Okay. Fair to say that when that pre-sentence investigative report is conducted, that the officer that would be in charge of preparing that report would look at whether alcohol or drug dependency was an issue in the underlying offense.
Yes.
Or was a contributing factor.
Yes.
And that would be, or would that be weighed heavily in the determination of what alcohol or drug treatment was recommended?
Yes.
And is there a spectrum of treatment available for drug and alcohol abuse or dependency?
Yes.
And I think you described starting from outpatient
Correct.
at kind of the low end to safe P or safe PF. And that is the substance abuse treatment component that is actually run in Huntsville. At least that's one of the treatment facilities.
Correct.
And would you agree or disagree that that safe PF is kind of more incarcerative?
Yes.
Meaning the person, the patient or client doesn't have the ability to come and go. They would be kept there.
Correct. And most of our facilities are locked down.
Okay. And would you agree or disagree that from your experience that safe P or safe PF is intensive?
Yes, it's a 9-month program followed by a 3-month halfway house.
Okay.
And then they come back into the community, and then there's another 12-week local aftercare program.
Very good. And that is somewhat self-guided, meaning if there's diligence in performing that program, there's kind of an over and under to that 9 months. Is that fair?
Yes.
Okay. With the whole idea being that community supervision, at least this jury would likely be given the instruction that it is a placement of a defendant by a court under a continuum of programs or sanctions with conditions imposed by the court for a specified period during which a sentence of imprisonment or confinement is probated. Okay. Would you have any reason to disagree with that?
No.
So being supervised in the community, that is going through the process of community supervision or probation. Is that, especially on a felony level, is that easy or difficult?
It's difficult.
Why?
Depending on the risk level and the offense, it could be reporting once a week. It's taking time out of their schedule, taking time off work to come in and report. The consequences for violating probation is obviously incarceration within a felony case. So, they pay a good amount of money to probation fees, to court fees. They have to do community service restitution and felonies. It's 200 to 400 hours. They have to do all of their programs. Depending on it, it could be once a week for 5 to 8 years, or it could be, a 12-hour course.
Okay. You mentioned community service restitution, and that can be sometimes hundreds of hours. Have you seen that before?
Yes.
And are you familiar that the judge, as a condition of probation on a felony case, can impose up to 180 days in the Hayes County Jail as a condition of probation?
Yes.
So a half year, 6 months.
Yes.
And that would be served day for day.
Correct.
Meaning there's no early release, there's no good time credit. We hear that term used sometimes. It would be if 180 days is assessed, the client would be there for 180 days.
Correct.
This jury yesterday returned a guilty verdict on a sexual assault. Is there what's called a sex offender caseload?
I actually supervise sex offender caseload.
Okay, tell us more about that.
So no matter what their risk level is, for at least the first 2 years, they are on intensive supervision. And so that basically overrides their supervision level to a high. At that point, they are reporting every week. unless they are participating in a program. We have a cognitive class called moral recognition therapy. We do have the sex offender treatment program in-house, whether they're in a substance use group, as long as they are participating in a group, then their reporting would go down to a minimum of twice a month.
And so you've already described how felony probation is very difficult. There are lots of requirements. There are lots of conditions that would be expected to be successfully completed if somebody is on probation.
Yes,
Adding the additional components of that sex offender caseload, does that make that more or less difficult?
more difficult,
It's very intensive. Would you agree?
correct,
It imposes quite a few extra conditions.
yes,
And are you familiar with the CR 32 form?
yes.
And what is that form?
It's a sex offender registration form for DPS.
Okay. Judge may approach.
Nay. Thank you, Your Honor.
And that CR 32 form, that sex offender registration form, are you familiar with what it looks like?
Yes,
And is this a fair and accurate copy of one of those forms?
yes,
And does it appear, with the exception of that defendant's exhibit sticker on it, does it appear to have been altered in any way?
no,
Judge, upon tendering to the state defendant's exhibit P16, defense would seek admission of that exhibit.
Judge, we would object to hearsay of the document itself. This witness can explain what what those sex offender conditions would be, but to enter the documents that may or may not be used, I think is hearsay and not relevant.
Judge, it is a government record.
Government record?
Yes, Your Honor.
You can
It's
approach.
Department of Public Safety. And it has state of Texas at the very top of it.
It's a blank form.
Lots of paper, guys. Yes. Thanks, Norm. Yes. Objection is sustained. Okay.
We can't admit it in front of the jury, but you're very familiar with this form.
yes,
Is that fair?
yes,
I would assume that you look at these forms every day in your role supervising that sex offender caseload.
I wouldn't say every day, but I see them regularly enough.
Okay, fair enough. And it requires somebody, would you agree or disagree, that they have to register every year on their birthday?
Yes,
And that is for the offense of sexual assault, that is a lifetime registration requirement.
correct,
There are two different kind of buckets that you can put sex offender registration, and that is some offenses necessitate a 10-year registration requirement.
it's post 10, so it's 10 years after the end of supervision or the release from incarceration,
That's exactly right. And then there is a lifetime registration requirement,
correct,
and sexual assault falls in the latter.
yes,
It's a lifetime registration requirement.
yes,
It requires the CR 32. You're familiar that this would be imposed immediately upon a sentence of community supervision or probation.
Yes,
And it would require the client, the defendant, to register with the local law enforcement authority and the municipality that they live in, or the sheriff's office if they live outside the city limits,
yes,
within 7 days of moving from one residence to another.
yes,
They are required, would you agree or disagree, to update their driver's license on an annual basis instead of kind of the more relaxed every 3 or 5 years.
that's correct.
And they would have to, if they travel to one place more than a few times a month, they would have to register in that municipality as well.
Yes,
Even if somebody with cancer or a chronic health condition is hospitalized for a period of more than 7 days, they would even have to register and say that they're in the hospital.
yes,
Okay. That would be a special significance for somebody with an acute chronic health condition like cancer.
yes,
If there's a change of employment, they would have to register within 7 days.
yes,
So we've talked about, while it is quite difficult, very difficult, especially in the sex offender caseload, kind of the relative carrot of being supervised in the community as opposed to incarceration. But I want to talk about the stick a little bit. You mentioned that if there was a proven violation of any of those probation conditions that you discussed earlier, any new criminal offense, or if somebody uses alcohol, or if somebody doesn't complete treatment, that they could be incarcerated.
that's correct.
Are you familiar with the term exposure, or a client's exposure on probation?
Yes,
And what does that refer to?
that's gonna be sort of the underlying incarceration term, if they do violate that probation.
Okay. And under Texas law, up to 10 years in prison can be probated.
Yes,
So a jury or judge could assess a prison term of up to 10 years, and that term of incarceration would be probated.
Judge, at this point, I'm gonna object to improper legal conclusion. The jury will get the law from the jury charge. I don't think we need to go over it right now.
Sustained.
In general, there is a period of incarceration that is probated.
Objection, Your Honor, same objection.
Sustained.
There is exposure, and then there's the period of probation.
correct.
And if there is a violation of any probation condition that is proven, a motion to revoke could be filed,
Yes,
and that person could be sentenced anywhere up to 10 years.
yes,
At a high level, while probation or community supervision is difficult, would you agree or disagree that the goal is to provide adequate treatment,
yes,
to provide the client with the tools that they need through counseling, through treatment, to address underlying issues that may have contributed to their commission of some kind of criminal offense,
yes,
to rehabilitate?
yes,
I'll pass a witness, Your Honor.
State.
Ms. Saylor, can a defendant receive counseling and treatment in prison?
I believe so, yes.
We even discussed that Safe P is one of those drug treatment or alcohol treatment programs in prison.
Yes, however, they do not accept sexual assault cases for whatever reason.
Do you know if this defendant lives in this county?
I believe he does not.
So would Hayes County's probation department even be the one supervising this defendant?
Not day to day, no.
Would that be the county where he resides?
Yes,
If he resided in Williamson County, would they be the ones doing the day-to-day check-ins?
yes.
Do you have any knowledge about what the Williamson County Probation Department does?
As far as their sex offender unit, they do have, officers that only supervise the sex offenders. They have, probably a little bit more stringent requirements than we do. They do more, field visits. They have a specific field visit unit. So they're going to their houses, digging through devices, making sure that, the defendant's not viewing any material they shouldn't.
Do you know how often they make home visits?
I don't.
Do you know how often they would dig through devices?
I think they do it at every home visit. I'm just not sure what the frequency of those are.
And that's because every county's probation department is different, correct?
Correct.
There is no set standard for how often you need to check in on a defendant.
Correct.
That's determined by the county themselves.
Our department policy, yes.
Exactly. And so if probation were given in this case, we don't really fully know how often Wilco or Williamson County would be doing those things.
So we would send our conditions of probation over there, and then they would supervise them per our conditions. Also, we'll kind of keeping within their policy for their department. And so if there's, maybe a class, like not many counties offer the moral recognition therapy. So they will sort of say, well, we don't have this class, but we have this other alternative.
Something as similar as they can get,
That's right.
but we don't know what group.
Correct.
If a defendant has shown that he's violated conditions of bond, would you have concerns about his ability to follow conditions of probation?
Yes.
When a person on probation violates, do they get sent to prison right away?
No.
What's the process of what that looks like when there is a verifiable probation violation?
Our department policy uses a progressive sanctions model. So sort of depending on the violation, we take it from there. If it's something like his drug screen comes back positive for alcohol or marijuana, then we may sanction him with some classes, increase reporting, increase drug tests. If it's something as serious as finding, pornographic material on a device or a new offense, then at that point we would bring it before the court.
And when you say bring it before the court, would you let the prosecutors know?
Yes, we staff it at our office with other probation officers. We come up with a recommendation. We write a violation notice and that gets submitted to the DA's office.
But then that has to be presented to the court, correct?
Yes.
And ultimately, a judge would determine whether or not more classes, more probation, or whether their probation is revoked, correct?
Correct.
And it's only when a judge decides that probation is revoked that that defendant would potentially go to prison, which his I guess sentence would allow it to.
Yes.
How many chances do defendants get when they break the rules of probation?
So with the progressive sanctions, like it does depend on the violation. If it's simply, drug or alcohol related, then we will offer amended conditions or additional conditions to either up the treatment, if it's a new arrest, the first thing right away is to submit the violation notice.
So a defendant could mess up on smaller conditions a number of times and still never get an official violation notice.
Correct.
And that is just up to the county's probation department, correct?
Correct.
And so that would be, if this defendant lives in Williamson County, that would be up to Williamson County to tell us about whether there was going to be a violation.
That's correct.
All this to say, there's really no bright line way that we can know whether or not this defendant is going to follow all of their rules, correct?
Correct.
Because he might break some and we might never know.
Correct.
Nobody's watching him 24/7, right?
Correct.
It would just be when that county that he resides in decides to go and do these checks.
Yes.
Or if the defendant self-reports,
Yes.
which I'm assuming doesn't often happen, correct?
The sex offender caseload, part of their therapy is kind of a commitment to total honesty. They do have to submit 2 polygraphs. And so if there is, we've had a good number of defendants, looking at pornographic material because they did it on a polygraph. But, polygraphs aren't perfect. So.
In a second-degree felony case like a sex, do you have some defendants here in Hayes County that are on probation?
Yes.
Do we also have some though that are in prison?
Yes.
That's what.
Vince,
Just a few follow-up questions, Your Honor. But you would agree with me that whether or not somebody's being day-to-day supervised or in another county or day-to-day supervised here, there is some element of trust that they are going to abide by the conditions, and that none of your probationers are supervised every minute of every day.
That's correct.
But is it also, would you agree or disagree with me that rehabilitation works, that you have clients, probationers on your caseload that successfully complete their term of supervision
Yes.
and have been rehabilitated,
Yes.
have been provided the tools that they need to address perhaps underlying issues in their lives that led to their criminal behavior?
Yes.
Is it common, and in fact, would you agree or disagree that that's one of the main purposes of probation, is that you might have somebody with an as yet undiagnosed substance abuse issue where they finally get the treatment that they need on community supervision or probation?
Yes.
And if, would you agree or disagree that while somebody may be courtesy supervised, or are you familiar with that term?
Yes.
And that just means where they would be supervised in one county, but the sentencing county would be something different.
Yes.
If somebody was found guilty in Hayes County, they would be courtesy supervised perhaps in Williamson County.
Yes.
If there was an alleged violation of probation, would Williamson County address that? Or would all relevant legal proceedings happen in Hayes County?
So the way that works is Williamson County would send a progress report to the local officer here. Then the local officer would make a decision on that. So like I said, with the alcohol and drug sort of, what we consider a technical violation, we would tell them what our policy says to do, and the sanction would be carried out in Williamson County. If it is a new arrest, we actually get, it's called a flash notice from DPS letting us know that he has been arrested. At that point, we would request a progress report so we can get a snapshot of sort of where he's at in his supervision, and then we would write the violation notice.
If somebody was convicted in the 483rd Judicial District Court, the presiding judge of the 483rd Judicial District Court would determine the appropriate resolution.
Yes.
Pass a witness, Your Honor.
No redirect or recross, Your Honor.
May this witness be released?
Yes.
Your Honor.
No objection from the state.
Thank you, ma'am. You're free to go about your business. Defense, call your next witness.
Judge, defense calls Zach Masters. Yes. Oh, I'm sorry.
Raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth.
Yes, sir.
Please have a seat. Adjust yourself close to that microphone, about a fist away from it, and it'll move up and down if you need to. There you go. If you would, please tell us your name and spell it for the court reporter.
My name is Zachariah Masters, Zacharia. Masters, Masters.
Defense.
Thank you, Your Honor. Zach, how are you today?
Doing well.
Good. Where do you work?
So I work with my dad. We own a company called Freedom Fund. We're a party rental company.
And how big is that company?
Currently, we have about 20 locations across 9 different states. We started off in Leander, which is a small family-run business, and now we're a franchise brand.
Do you have any kids?
Yes, sir. I have one.
And boy or girl?
A girl. Her name's Brady.
And how old is Brady?
She just turned 5.
Happy birthday to her. Do you know Lincoln Pearson?
Yes, I do.
How do you know Lincoln?
I know Lincoln. We met in high school about 14 years ago in theater tech class.
So you've known him how many years, if you could estimate?
I think 14.
14 years?
Yeah, his junior year of high school. I graduated in 2013. So.
I want to talk with you about a period of your life. Has Lincoln helped you and your dad during an expansion of that company that you visited with us about?
You know, during the infancy stages and like the building blocks, like we're setting the foundation for the company, I was involved in a motorcycle accident. I had a C1, C2 fracture, fractured my orbital eye socket, ruptured both my lungs, broken ribs, you name it, I had it. And I was completely incapacitated, like wearing a halo. And Lincoln, he stepped up. I didn't ask him to. My dad didn't ask him to, but he stepped in. He didn't, need the money or anything, but he helped my dad alongside him, like do a bunch of the parties and stuff. The early stages, it's really important. It's like you're late to a party, you don't show up, you get bad reviews and stuff, and it's over. So he just stepped in, helped us tremendously while I was out.
Would you agree or disagree that at an early stage in a company like that, it can snowball kind of one or two directions, and that's in a good direction or a bad direction?
100%. We were one store at that time. We were just local in Leander.
At this point, I'm going to object to relevance as to as to what business help this defendant gave, I don't think it's going to help this jury decide the punishment in this case. I don't believe we've even at that low bar of relevance.
Response?
Yes, Your Honor. Judge, I believe this jury is assessing this defendant's ability to, well, Judge, may we approach?
No? What's your response to that relevancy objection?
That it is relevant, that it does provide assistance to this jury in assessing relevant character traits that could be imperative in their decision on the appropriate punishment and whether or not he can complete the required conditions of probation. And is relevant.
Overruled, you can continue, but make sure it's relevant.
Thank you, Your Honor. So you mentioned that this wasn't something that he had to do, but it's something that he demonstrated an ability to be goal-oriented.
Objection, Your Honor, leading, can we also allow the witnesses to give the evidence?
Sustained.
I'll
Don't lead your
leave it.
witness.
Would you agree or disagree that during that time, that demonstrated to you his ability to be goal-oriented?
Agreed.
And would you agree or disagree that during this time and his assistance in that process, that infancy stage of your company, that there were things that had to get done?
Yes, agreed. He was very supportive during that time.
And did he do those things?
Yes.
I want to talk to you a little bit about your daughter. Does Lincoln have
Objection, Your Honor, relevance as to this witness's daughter. We're not even talking about the defendant.
Response?
If I can finish the question, Your Honor.
Yeah, go ahead and finish.
Thank you, Your Honor. I want to talk to you about your daughter, and you have a daughter, you said it's about 5 years of age.
Yes.
And does Lincoln have a daughter about the same age?
Yes.
Have you and Lincoln, did you go on this fatherhood journey together?
Yes, we did.
Is that fair to say?
Yes, it is.
Are your daughter and Lincoln's daughter friends?
Yes, Riley calls you to be her best friend.
Do they know each other very well?
Yes.
And do you interact with Lincoln and Genevieve quite often?
Yes, we get together a lot.
Judge, objection to relevance. We've already heard about this witness or this defendant and how he's a father. I don't believe that it is relevant to go and talk about how he is with every other person's child.
Sustained.
Have you observed his interactions with his daughter?
I have.
And have you observed him to demonstrate qualities that you associate with being a good father?
Absolutely.
Is he caring?
Yes.
Is he responsible in his fatherly duties?
Yes.
Does he love his daughter?
Yes.
Does she love him?
Yes.
I want to visit with you about a decision that, an important decision that you made in your life 6 years ago. What was that decision?
I made the decision to get sober. I went into AA and started my journey of recovery.
And through that experience, fair to say, like most people with alcohol dependency issues, did you hit a point of rock bottom?
Yes, I did.
And through that experience and going through alcohol dependency, do you think you have a good familiarity with some of the warning signs of alcohol dependency?
Yes, I do. My father was an alcoholic, so I've been around rooms since I was a little kid. So yes.
Okay. And were you seeing some of those warning signs in your own life?
Yes,
And based on those warning signs, what did you do?
I just made the decision to change one thing, and that was everything. And I entered the rooms of AA, and by the grace of God, I was able to, flip the page in my book and just become a totally new person.
Has that been a positive experience in your life?
The most positive, yes.
Through that experience of alcohol treatment, has that given you tools that have led?
Objection, Judge. We've got to keep it to about the defendant. This person's journey in AA is not relevant. We're here to talk about the defendant.
Judge, it is relevant if it lends credibility to his ability to recognize issues of alcohol dependency in others and concepts and theories that he's learned through that treatment to recognize alcohol issues in other people.
Then let's talk about that with the defendant. But we
Judge,
haven't gotten there.
and we have to establish that through questions, Your Honor.
Overruled.
Thank you, Your Honor. Through that experience, again, have you come to recognize some warning signs in other people? Is that fair to say? Issues related to alcohol dependency?
Yeah, I think it's fair to say.
And have you been sober since your decision to exclude alcohol from your life?
Yes, I have.
And has that yielded positive results in your life?
Unimaginable results, yes.
I want to talk to you about Lincoln and your interactions with him. Do you think Lincoln could benefit from intensive alcohol treatment?
Yes, I do.
And we visited about what community supervision or probation is, and that it is a continuum or spectrum of programs that begins with an assessment for any alcohol dependency and then would provide some treatment component to that. Fair to say?
Yes,
Is alcohol treatment something that you think Lincoln could benefit from?
absolutely, yes.
I'll pass it over to Sean.
Six.
Whenever you struggled with alcohol dependence, did you ever forcibly rape someone?
No.
When you ever struggled with alcohol dependence, did you ever sexually assault someone that was unconscious?
No.
When you struggled with alcohol dependence, did you ever beat your girlfriend?
No.
Did you ever take a broom to your girlfriend's body and cause her to bleed?
No.
What do you think an appropriate punishment would be if somebody sexually assaulted your daughter?
I'm not here to play the judge. I don't know if there's substantial evidence for that. I would definitely want that person held accountable, but it's not for me to decide.
Consequence.
Vince.
Yeah, just a few follow-up questions, Your Honor. You would agree that accountability can have a lot of different complexions. Is that fair?
Yes,
If this jury assesses community supervision or probation, would you be supportive of Lincoln in that journey?
100%, yes.
Was he supportive in your sobriety journey?
Yes, he was.
And is it necessary and crucial that you have somebody supporting you along that process?
Yes, the support system is very crucial and beneficial.
In your journey, Did you have few or many friends that supported you?
I could count them on one hand. You make a drastic change like that, you know, you lose a lot of people. But Lincoln did stick by my side during that time.
He was one of those five,
Yeah,
less than
sorry.
five people.
Yeah, there was, yeah, him and like two other people.
Would you be that for him?
Absolutely.
I'll pass the witness, Your Honor.
No, witness.
Has witness been released?
No objection.
No objection, Your Honor.
Thank you, sir. You're free to go about your business.
Okay, thank you.
Vince, call your next witness.
Judge, may we approach for a housekeeping issue?
You may.
Thank you, Your Honor.
Yes. Deputy. Could you please take the jury out into the hall for just a moment? All right, so the jury. We're outside the presence of the jury. Defense.
Thank you, Your Honor. Lincoln, we have discussed, as we discussed with you during the first phase of the trial, during the guilt innocence phase, that you have the right to testify. Is that right?
Yes, sir.
And we've discussed with you in this phase, just as we did in the first phase, that I cannot keep you from testifying if you want to testify.
That's correct.
And I can't make you testify if you don't want to testify.
That's correct.
Knowing all that and knowing that it is your exclusive decision to testify or not testify, do you want to testify?
No, I do not.
Thank you, Your Honor.
Anything else?
No, Your Honor.
Do you have other witnesses?
No, Your Honor.
We will bring them in, set them down, let you close. Any rebuttal witnesses?
Rest and close, Your Honor.
Send them for a break. Then we will discuss the charge. I don't think that should be very long.
No.
And then we'll get started.
Yes, Your Honor.
How
Okay,
long for closing stretch?
we'll talk about that in a moment. Just let me think.
Sure.
What in?
All rise for the jury.
You may be seated. Defense, please call your next witness.
Your Honor, at this time, the defense rests.
State,
Rest and close, Your Honor.
defense.
We close as well, Your Honor.
That's all the evidence you will hear in the punishment phase. What we're going to do is give you the opportunity to take a break. I'm going to talk about the jury charge that I will read to you. That's the law that applies to punishment. So y'all will take a break. Then we'll bring you back. I will read you that charge and we'll have the closing argument. That means it's just going to be a little bit longer, and I want to go ahead and give you your afternoon break. So you have that opportunity. When we come back, we may be in here for about an hour. So just keep that in mind. Also, if there are any phone calls or anything you need to make, do that now, because when you come back, you will go straight. When you come back, you won't have your phones. When you go back to the deliberating room next time, you will go straight to deliberations. So just keep that in mind. Remember, don't start talking about the case until all 12 of you are together. Thank you.
All rise to the jury.
All right. We get to stay on the record. I approve. provided a copy of the proposed jury charge for you. Any objections from the state,
No objections from the state, Your Honor.
from the defense?
No, Your Honor.
Okay. Then we will come back and begin with reading the charge and your closing arguments. Ruby, we're off the record. Do you need to go take a break? 15 minutes?
15, I was gonna recommend.
Yeah, 15 minutes.
Perfect.
Aside.
Thank you, Your Honor.
You're welcome. Right, we're in recess. May be seated. I will now read you the charge of the court on punishment. Ladies and gentlemen of the jury, by your verdict, you have found the defendant, Lincoln Anthony Pearson, guilty of the offense of sexual assault as charged in the indictment. Now you must determine the punishment to be imposed on the defendant. You are instructed that the punishment for sexual assault is confinement in the Texas Department of Criminal Justice, Institutional Division, for any term of not more than 20 years or less than 2 years. Therefore, you will assess the punishment of the defendant at any term of not more than 20 years or less than 2 years. In addition to imprisonment, an individual found guilty of the offense of sexual assault may be punished by a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. The defendant. Can the attorneys approach? The defendant has filed an application in writing under oath, stating that he has never before been convicted of a felony and has requested that the imposition of any sentence imposed be suspended and that he be placed on community supervision. Community supervision means the placement of a defendant by a court under a continuum of programs and sanctions with conditions imposed by the court for a specified period during which a sentence of imprisonment or confinement, imprisonment and fine, or confinement and fine is probated, and the imposition of sentence is suspended in whole or in part. Our statutes provide that where a defendant is found guilty of the offense of sexual assault, and the jury assesses the punishment at not more than 10 years, and they further find that the defendant has never been convicted of a felony in this or any other state, the jury may, within its discretion, recommend community supervision. Whether you do or do not recommend community supervision for the defendant is a matter that rests within the sound discretion of the jury. If the jury does recommend community supervision, it will be granted by the court. If you recommend that the defendant be placed upon community supervision, the court shall determine all the conditions of community supervision and may, at any time during the period of community supervision, alter or modify the conditions. The court may impose any reasonable condition. You may not recommend that part of the period of confinement be served by incarceration and part by community supervision. Should the punishment assessed by you include a fine, a recommendation of community supervision should state whether or not the fine will be paid or be suspended and probated. If there is any evidence before you, the defendant may have previously committed offenses or acts of misconduct other than that for which you have convicted him, you are instructed that this evidence, if any, was admitted to assist you, if it does, in determining what sentence is appropriate in the case at hand. You may consider that evidence in assessing punishment. You may consider that evidence only in assessing punishment only if you first believe beyond a reasonable doubt that the defendant committed such other offense or act of misconduct, if any. In the event you have reasonable doubt as to whether any such offense or acts of misconduct was committed, or as to whether the defendant was involved in such other offense or act of misconduct, then you will wholly disregard the evidence, if any, which may relate to any such matter. Our law provides a defendant shall be permitted to testify in his or her own behalf during the punishment phase of trial. If he elects not to testify, that fact shall not be taken as a circumstance against him. You are instructed that you cannot and must not refer or allude to that fact throughout your deliberations. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under these instructions, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, the defendant is not eligible for release on parole until the inmate's actual calendar time served without consideration of good conduct time equals 1/2 of the sentence. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. Suitable forms are attached for your verdict if you would like to use them. However, such form is not intended to influence you in any way in arriving at your verdict. In any event, your verdict must be unanimous, in writing, and signed by the foreperson. Signed by me, Tanner Neidhardt, 483rd Judicial District Court, Hayes County, Texas. And the verdict on punishment form reads, we, the jury, having found that the defendant, Lincoln Anthony Pearson, is guilty of the offense of sexual assault as charged in the indictment, now return this verdict as to his punishment. 1, we assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of, and there is a blank. You will fill it in with 2 to 20 years. 2, in addition, we assess, and you will check one or the other of A and B. A, no fine, or B, a fine of, and there is a blank. If you choose B, you will fill in the amount of the fine, and that will not be more than $10,000. 3, these are to be answered only if the jury has assessed 10 years confinement or less. A, and there's a blank. We have not assessed a fine, and we recommend that the term of confinement we have assessed be suspended and the defendant be placed on community supervision. If that is your decision, you will check that blank. Or B, we have assessed a fine, and we recommend that only the term of confinement we have assessed be suspended and the defendant be placed on community supervision. If that is just the decision, you will check that box. Or C, we have assessed a fine, and we recommend that both the defendant's term of confinement we have assessed and the obligation to pay the fine we have assessed be suspended during his good behavior on community supervision. That is your verdict. You will check that box. Or D, that the defendant's application for community supervision be denied. After completing those blanks, the foreperson will sign his name to the verdict form. State, are you ready to give your closing argument?
Yes, Your Honor. We just have the screen switched over. May I proceed?
You may.
Thank you. All right, guys. We believe her. And what now? Justice for Carissa? Justice for Dulce? Justice for every other woman that this defendant might ever come in contact with? That's what we're going to ask you guys to do now. You heard from the very beginning of this trial from the table over there. This is a very serious second-degree felony. Yes, it is. We agree. And we'd like you all to treat it as such. The punishment range of 2 to 20 years. You, as the jury, have that full range. You get to pick a number anywhere in there. Now, I'm not telling you this is a 20-year case, okay? It could be, it may not be. That's for you to decide. But what I will tell you, with a really vicious sexual assault, where there are severe injuries or a weapon is used, that is a higher level offense with a higher level range. This range, 2 to 20, is what is intended for this kind of offense. But I also want to tell you, this is not a minimum case. This is not a 2-year case. He's not squeaky clean. He does not deserve the minimum. But you guys decide. 10 years is an important number, and like it says in your charge, if you give him between 2 and 10, so less than 10 years, he can have probation. He's eligible for that. If you give him more than 10 years, he is not eligible for probation. But you also can give him between 2 and 10 years and say no probation, okay? And that's what we would ask you to do, is on your verdict form, line D, that the defendant's application for community supervision be denied. That's what we think is appropriate in this case. However, if you feel differently, if you feel like this is a probation case, we ask that you assess 10 years in prison. The reason we ask you for that is so that as the defendant does his probation, he has that max hanging over his head. He has an incentive to do the right thing. And that if he does mess up, the judge has a full range to work with, okay? If you assess, low number of years and give him probation, he has much less incentive to do well. However, like I said, we think, don't worry about it. Just sign line D and assess a number in this range. Hold him accountable. You heard the testimony today. I don't believe that this man has ever been held accountable a day in his life, certainly not by his mother. And as the defense gets up here and talks to you about what a great dad he was, as what you guys all should remember, he was already the world's greatest dad when he assaulted the mother of his child and when he raped his best friend's girlfriend. Thank you.
Vince?
If I can have just a moment to prepare the court. Your Honor. May I proceed, Your Honor?
You may.
Ruby, is that on?
No.
How's that? May I please the court?
Ladies and gentlemen of the jury, I just want to start off by thanking you for your service. We understand that the testimony that you heard this week was difficult. You know, it's almost an impossible job that we ask you to do. We pluck you out of your lives. We take you away from your families, from your work. We bring you in here to court and you hear testimony. You hear testimony from witnesses that is difficult. And we understand that your decision was difficult, and we appreciate your attention during the trial, and we appreciate your service. What I would say is that assessing guilt and innocence, the first part of the trial, is a review of the testimony. It's a review of the facts. It's a review of the evidence. And it is difficult, but there are bold letter guidance. Your decision is essentially black or white. The decision that you now have in front of you is not. It is a spectrum. And thinking all the way back to Monday when you were seated out here and we discussed the range of punishment, we discussed that probation was an option here. And if you remember, there were potential jurors that could not consider probation for this offense. There's a reason that they are not here. There is a reason that you are. And it's because you can follow the law and you can consider the whole range. I would offer you that assessing punishment, the appropriate punishment, and to be clear, no matter the punishment that you bring back, whether it is probation or community supervision or prison, it is punishment. It is accountability. No matter what it is. And you've heard testimony about that. And I would say that assessing punishment is a balance of things. It's a balance of several different concepts in our criminal justice system. It's a balance of retribution, certainly, of deterrence, certainly, accountability, but rehabilitation as well. 2 to 20 years or probation. We are asking you for probation. If you're inclined to recommend probation, keep in mind that your answer to number one,
must be somewhere between 2 and 10. I agree. It should be 10. Feel good about your verdict and feel good that the presiding judge of this courtroom will have the complete available legal range of punishment as a stick. As a consequence, if Lincoln Pearson doesn't abide by the conditions of his probation. We agree on that. Give him 10 years. We agree. However, and how do you know that it has to be somewhere between 2 and 10? Because your jury charge tells you that the jury cannot assess punishment. If you want to give probation, your punishment cannot be more than 10 years. That's the maximum amount of time that can be probated. However, we are asking you to check one of these 3 boxes. And it doesn't matter. If you assess a fine, that is your decision. That's a decision for you guys to make. If you do assess a fine, we would ask that you probate that. But we're certainly asking that you probate that prison term. You're asking that you probate that. Again, you heard testimony that if you recommend probation, the judge would have to grant it. And the judge will decide the length of probation and the appropriate conditions. And you heard some of those conditions from the probation officer. And I have every reason to think that if you recommend probation, that it will be a lengthy term of probation. I fully expect that. Up to 10 years. You've heard testimony that he will have strict conditions of probation to complete. Community service, serving the community, serving the state of Texas. Every time you drive past people that are picking up trash on the side of the road, some other job out in the 103-degree heat in the summertime, that's what they're doing. Serving the community. That is punishment. That is accountability. You've also heard that the judge can assess a jail term of, and while you may not recommend that part of the period of confinement be served by incarceration and part by community supervision, you did hear testimony from the supervision officer, from the probation officer, that the judge can, even if probation is recommended, the judge can assess up to 180 days in jail. Here in Hays County, that the defendant would have to serve 6 months in jail before he even gets to start his probation. That can be served here in Hays County. Up to 6 months, day for day, no early release, right? You also heard that no matter what your sentence is, no matter what it is, no matter what your recommendation is, Lincoln is going to have strict requirements that are mandated upon him by the Texas Department of Public Safety related to his duty to register as a sex offender for the rest of his life. That won't change, regardless of your assessment. For the rest of his life, his name and his photo will be on the Department of Public Safety's website. Anybody can look it up. He'll have to register once a year on his birthday. He'll have to register anytime he changes addresses, anytime he moves jobs. He will have accountability through the state of Texas. And if he doesn't, he a new felony criminal offense. Now you've heard that Lincoln only has one prior conviction, that misdemeanor DWI conviction from California that was 6 years ago. That's the testimony that you've heard. There's only that one California misdemeanor DWI to contextualize the work that you have to do now. That rap sheet from California, that one misdemeanor, not a felony, which means that he is eligible for probation, not a felony. That is what you have to give you context. We recognize that this is difficult, and you've heard testimony from Dulce, and you've heard testimony about their relationship. And I would offer you that there is nuance there. And while she said it solely rested on Lincoln's shoulders, that he was the only toxic part of that relationship, I would offer you that that runs counter to our experience, to our life experience, to our common sense. That any part of a relationship, there is going to be blame to be spread around. I know it certainly is. My slice of the pie between me and my wife, I probably take the lion's share. But that is just not common sense, folks. And you can believe or disbelieve any part of that. He's certainly never been convicted of any kind of family violence. That can be your decision. And we recognize this is difficult. We recognize that there are lots of emotions involved. There have to be in a situation like this. So how do you take account of all of this? What is fair? What is fair in a situation like this? You heard, we come into court, we have a concept of what probation is. That it's easy, it's just a walk in the park. You just go home. But you heard that that is not reflective of reality. And you heard that from no less than the probation officer that administers, that would be administering his probation, the sex offender caseload. You heard that it's not easy, that it will be difficult, that he will have accountability, that he will have punishment. He will have all of those things, that there is accountability. Now, there is a carrot. He has those conditions to complete. He has community service to complete. But there is also a stick. And the exposure that you assess between 2 and 10 years, that will be his consequence if he is not perfect, if he does not abide by those conditions of probation. He will have a consequence. But we're asking you for a chance. So how do you put this in context? We hope it's that by an understanding that he is a son, he is a brother, he is a friend, he is an employee, he is a father. We hope it is by an understanding of those things. And we know that you've heard testimony that he loves Genevieve with all of his heart. And he is terrified right now. No doubt about it. Because, not terrified because his life is in your hands, though it certainly is. He's terrified right now because his relationship with his daughter will be changed dramatically. There is no escaping that. But whether or not he has a relationship with her over the next 10, 15, 20 years, or he doesn't, that is what he's terrified about. And it's my hope that you also have an understanding of his battle with cancer. That was raging, that was aggressive at the time this sexual assault happened. And everything that was going on in his life, this tumultuousness, everything was clustered around that year window in time. When he was diagnosed, when he received surgery, when he was being treated. We've certainly meant to demonstrate to you that he is a very good father, that he does work hard, that he does provide for her, that he is a good dad, that he is a good parent. And he's terrified that all of that work, all of that improvement, all of that ascension over the last 5 years is in danger, is in jeopardy right now. You know, at a prosecutor's conference a long time ago, back when I was a prosecutor, I heard a quote that stuck with me, and it's from a guy named Eric Cohen, who's a criminologist with Right on Crime, and it's a conservative criminal justice group, and he says, Prison is for the people we're scared of, not the people that we're mad at. And while some members of you in this jury may certainly be mad at Lincoln, sir, understandably, given the testimony that you've heard this week, I also believe that those elements of his humanity, the fact that he is a good father, the fact that he is an exceptional friend, that he devotes his life selflessly to a good friend who's been tragically injured, whose business that he's worked very hard for is in danger, in jeopardy. And he sacrificed his time so that his friend's business could thrive. He sacrificed the judgment of friends and peers to help his friend out in his time of need, in his time of sobriety. But he also has the benefit of that friend helping him through this period in his life. He has a support system. And folks, going through rehabilitation like this, addressing those issues related to alcohol, you need your community.
Counsel, you have less than a minute.
Thank you, Your Honor. Not people in the jailhouse. That's what you need. So the question is, can we forgive? Forgiveness doesn't suspend judgment, doesn't mean not holding people accountable or ignoring injustices, forgetting the past. It simply allows for the possibility of atonement and progress, and perhaps redemption. There's a tug of war between retribution and rehabilitation in the criminal justice system. And just like in this case, like most cases, except when there is no possibility of parole, there is life at the end of the tunnel. There is an end date. And the fact that there is an end date, I think, implies implicitly that we as a society believe in redemption at some level.
Counsel, that's your time.
Thank you, Your Honor. And I would offer you that the reason that we forgive is not to let him free, it's to let ourselves free. It is to release ourselves. And it's not a gift for him, it is a gift for everybody involved in this, including yourselves. And for those reasons, we respectfully request and that he be given a chance on probation, that he be allowed to go home to his daughter with the accountability that comes with it. We thank you for your service.
Oh, is this gonna work?
Yes.
I'm kind of shocked right now about how much been spent on talking about Mr. Pearson's role as a father. because I wish that while his daughter looked like this, he was thinking about her instead of doing this to his daughter's mother and breaking the broom over her body. And I wish that if he was such a good father, that instead of forcibly raping our actual victim in this case, Carissa Ellis, that he was being a father when she was 1 year old. I honestly don't take any of defense arguments. I don't think they're worth it. And you hear his family sneering in the back. He's been on probation before. He's done community service, even though it was just 24 hours. He's had to do drug treatment or go to AA meetings, even if it was just a couple. He's had to follow the rules, even if it was for a shorter period of time. It didn't stop him. And we got arrested for this charge back in 2020, and he was given rules while you're out on bond. He broke them. And sure, it was just drinking while he was out on bond. Didn't we hear that was one of the problems in this case? Didn't we hear that was one of the problems in 2 of the other times that he assaulted Dulce? We've given him the chance. And he's shown us who he really is. We've said, follow the rules, and he's told us as a community, I won't. And so now it's your chance. As members of the bar community, to actually hold him accountable once and for all. And say, you don't get to drive drunk. You don't get to beat your spouse or your girlfriend. You don't get to forcibly rape somebody when you're drunk and your 1 year old is at home. I think this case is actually pretty simple. The defense is begging you for mercy, is begging you to give him a chance. The members of the jury, he's used it up. Give him a prison sentence. That's what this case deserves. That's what Dulce deserves. That's what Carissa deserves. That's what this community deserves. Or tomorrow, do we want to wake up, see a newspaper headline saying that a sexual assaulter, a forcible rapist here in Hays County gets a slap on the wrist? It's not a county I want.
All right, ladies and gentlemen, the jury, you have all the evidence that you will receive in the punishment phase. You have the jury charge and you have the closing arguments of the attorneys. This will be your guide as you go through your deliberations. Refer to it if you have any questions. We will be in recess until you reach your punishment verdict. Bailiff?
All right, for the jury.
Anything we need to take up?
Yeah, Your Honor.
All right, we're in recess.
Thank you, Your Honor.
Yeah.
Okay. Okay, thank you, Sheriff. Okay. Yes, sir. Thank you.
Students, y'all want to come up? Oh, you have one? You have them in there?
No, I gotta go get him, but he's
Oh.
putting on now.
What's your timeline?
He's 1 minute, he's just gotta put his time.
Okay.
Judge.
All rise for the jury.
You may be seated. Would the foreperson please rise? I understand that you have a verdict. Is that correct?
Yes, Your Honor.
Is it unanimous?
It's unanimous.
Please pass it to the bailiff. Could the defendant please rise? Verdict on punishment. We, the jury, having found that the defendant, Lincoln Anthony Pearson, is guilty of the offense of sexual assault as charged in the indictment, now returns this verdict as to punishment. 1, we assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 6 years. 6 years. 2, in addition, we assess A, no fine. 3, we find that the defendant has never before been convicted of a felony in this or any other state, and we make the following recommendations on his application for community supervision. D, that the defendant's application for community supervision be denied, signed by the foreperson of the jury. Anything from the state?
Judge, just that, no.
Defense?
We request to poll the jury, Your Honor.
Very good. As we did yesterday, the verdict that I just read, I will go across each of you and ask you if the verdict that I read is your verdict. We'll start at the back on the left. Ma'am, we'll say juror number 1, so we know through 12. Juror number 1, is that your verdict?
Yes.
Juror number 2, is that your verdict?
Yes.
Juror number 3, is that your verdict?
Yes.
Juror number 4, is that your verdict?
Yes.
Juror number 5, is that your verdict?
Yes.
Juror number 6, is that your verdict? Start over here on the front, on the left. Juror number 7, is that your verdict?
Yes.
Juror number 8, is that your verdict?
Yes.
Juror number 9, is that your verdict?
Yes.
Juror number 10, is that your verdict?
Yes.
Juror number 11, is that your verdict? Juror number 12, is that your verdict?
Yes.
Thank you. I accept your verdict. You may be seated. All right, that completes your responsibilities and duties as jurors. We thank you very much for the time. And you know, I've said that many times, the attorneys have too. Understand how much we really mean that. We couldn't get to this position where you decide what is a crime, what is not a crime, what will be punished and will not be punished, unless you come here and do this duty. It's one of the most unique things that we do in the United States. It's the most direct way that we affect our communities. So understand that what you have done this week is very important, and I accept your verdicts and what you have decided. We thank you for that. We thank you for giving us that time. You know, I said at the beginning that I knew it would be a sacrifice for you to take away from your families, from your jobs for a week. And I know that that was true. But understand how much it was worth it, because what you have done is been a part of our criminal justice system, and that justice is the important thing. We can't get that if we don't have you. So thank you very much. The restrictions that I have given you so many times of the rules that you have to follow, those are now lifted. What that means, sometimes the attorneys like to ask you questions. Understand why. It's because the state will be trying other cases in the future, and maybe they can learn something from you. The defense will be trying other cases and protecting other rights. They may ask you some questions. You don't have to answer those questions. Just know that the restrictions are lifted. The bailiff will now take you into the back room, and I'll come back and thank you for myself in person. Thank you very much. You're free to go about your business.
All right.
You may be seated. All right. Anything we need to take up?
No, Your Honor, in this case, the victim chose not to allocate, she chose not to have a lifetime protective order. We do have a judgment for your signature.
Very good. I accept the court's verdict. I'll make a note of that in the docket and we'll sign the judgment. Anything?
Judge, we have a motion to withdraw, to file with the clerk by hand.
Very good.
Been served on the state.
Okay. I will take it
Yes.
and I will take.
Judge, may I approach?
You may.
We need a fingerprint, Judge. Can the fingerprint go?
Sure.
The motion will be granted.
Right down, up and
Your
down.
Honor. Judge, we've advised Mr. Pearson of his rights regarding a motion for new trial and the relevant deadlines for those. I don't know if we'll be seeking appointed counsel or hired counsel, but we've advised him of those rights. Sure.
Okay, you need to communicate that to someone if that's what you decide to do. I have signed the trial court certification of your right of appeal and it gives you a right of appeal. That's your decision, but that will be added to your file as well. Remanding you to the custody of the sheriff's office until they can transport you to the Texas Department of Criminal Justice. Good luck to you, sir.
Your Honor. And Judge, before the defendant is taken back, would it be possible to say goodbyes to his family?
I'm gonna leave that in the hands of the sheriffs. They're the ones that are in charge of security of the room. I
Does
have
the
no
court?
objection.
Thank you. That was my next question, Your Honor. Thank you, Judge.
Thank you very much. Anything else can you take up?
Nothing, let me say it.
Okay, we are in recess. Thank you.